Hi, everyone. Welcome back to another Wednesday webinar with Property Law Alliance. As always, it's so good to have you with us. And it's so good to have a full house this week. Greg, how are you doing?
Fine, Chris. How are you?
I'm very well, very well. Apart from the fact that I look like I just went for a jog, I'm good. I'm good. I'm ready for some property advice today, man. Cilna, how are you doing?
I'm very good, thank you. I don't look like I'm going for a jog. It looks like I'm, all summery. Well, it's actually super rainy. Look, so back to the weather with Cilna.
Bruno, how are you doing?
I'm good, man. I'm good. How are you doing?
I'm okay. Little bit, Bruno, be a little bit more enthusiastic to see me, please. You don't see me all that often.
I was just going to say, Chris, you look like you do a lot of running. You look like you man. I, on the other hand, spend all my time on my couch. So,
Wait,
guys,
I
it's
don't
so
think
good to
you
have.
do, Greg. I believe, Greg, not on the couch. I believe you definitely spend more time in court than the typical person I know. So you can't be on a couch.
that's true. But if I feel the need to run, I sit on the couch until the feeling passes. So.
It's usually gone in about 2 minutes, right?
You've got a couch in court. Is that what you're saying? Greg?
Couch there, got a couch there.
Oh, guys.
I surround myself with incentives not to run.
It's so good to have you all with us. I've got some great questions here today, some eviction questions and also some questions regarding lease agreements. So I think let's get into the first one, which is around a lease agreement. And this question was asked by a lady by the name of Alicia Hutchinson. Alicia says that she entered into a lease agreement, and that lease agreement stipulates that rent of a certain value is inclusive of water. She says that the agency that handles the lease agreement now unilaterally, without consulting her, cut the water supply and installed a water meter. And this happened mid-month. She says that as far as she is aware, the lease agreement is a binding contract, and that the agency in this unilateral move has now breached that agreement. But she says, look, right now she's sitting in a situation where she just doesn't have water because she can't afford to top the meter up. She wants to know whether that this action that's taken by the agency in this case to install the water meter, firstly, is legal, obviously without consulting her. And then secondly, is she entitled to a reduction in rental? Because I mean, she never budgeted when she entered into the agreement to now pay for water. So I think let's start with Bruno today on this one, and then Cilna we'll take it to you.
Sure. Look, so I think the simple answer to this is, I mean, it comes down to the contract. And I've seen this happen quite a lot when people aren't geared up, and you find this a lot with little cottages or buildings that never geared up for it. They all of a sudden decide that the rental's too low and people need to start paying for the utilities on top, above and beyond the rentals. And this is a very last minute thought. They didn't plan it ahead properly beforehand. Now, the problem there is the client or the viewer does have a point, because the reality is if the contract says that rent is 6,000 Rand a month, for example, inclusive of water and electricity charges, then that's that. Installation of water meters. So I'm assuming here you're referring to a prepaid water meter or prepaid meters in general. Now, so just a normal water meter to measure, that's allowed. Anyone can do that. I mean, it's the landlord's prerogative, but at no stage are they allowed to impede your use of any of the water or electricity. Now, to install a prepaid and saying that you need to pay your rent above and beyond that, you need to pay for the utility charges. That they're not allowed to do. And I've seen a lot of people try do this, especially when they take over buildings, for example, or like, huge premises that have multiple tenants in it, and they realize that the utility charges are way higher than what they're supposed to be, and now this is their way of trying to bring it in control, bring it under control. And unfortunately, you're not allowed to do that. You'd have to wait for the lease to expire, and once the lease expires, you allow it to expire. You don't, and you enter into a new lease, for example, and at that point you now include provisions that deal with the utility charges.
Yes.
Okay, I think then, sorry, so I think then the second part of the question, I think is not for you, but also I want your opinion on this first part as well, is around, is she entitled to a reduction in rental?
So I actually just want to jump back to the original question part of the thing, because the viewer says, and the question is, isn't the agent in breach of the lease agreement? And I think there's some clarification needed there. An agent can never, ever, ever, ever be a party to a lease agreement. There are only two parties to a lease agreement, a landlord and a tenant. And the agent, so you can't have a tripartite agreement where the agent forms part of the agreement. The agent is mandated by the landlord. So whichever actions the agent take is actually the landlord. So yes, I agree with Bruno 100%. The landlord is not acting in terms of the agreement, and the landlord is the one that's in breach of the agreement by not providing the utility that the parties agreed that the landlord will provide. So the agent is honestly completely innocent in all of this, in as far as it goes to, he is mandated on behalf of the landlord. Yes, if the agent went and did this without the instruction of the landlord, that means the landlord will now have a damages claim against the agent. But the landlord is still the only party that can rectify this breach, because he's the only party in breach, because he's the only other party in the lease agreement. So I know this sounds extremely technical, but I think it's very important. People very often think the agent is the landlord, but the agent only acts on behalf of the landlord. But I agree with Bruno 100%. You can't do this. In terms of the Consumer Protection Act, should this now be a fixed term agreement, Section 14 will dictate that 40 to 80 business days prior to the impending termination date of this particular lease agreement, the landlord will have to notify the tenant and say, we can extend the lease agreement, but now you're going to have to go with this prepaid meter situation. The tenant can then choose whether she wants to or not. But reduction in rent, definitely, at least just to the portion of the actual water. So it's not even a rent reduction like I was paying 7,000 Rand a month, water included. Now the water ends up costing me 300 Rand a month, but now I'm only going to pay 6,500 Rand. That was amazing mathematics for a lawyer. Can I get a high five, please, guys?
Nice.
Thanks, Chris. You didn't leave me hanging. I'm collegial of you boys. So yes, definitely rent reduction, but only to the actual value of the cost of the water.
Sure.
Okay, perfect. Thanks so much for that, guys. I hope that Alicia is actually watching us today. And if she's not, Alicia, there's some great advice that you just got there. I'm going to move quickly on to the next question, which is very interesting, actually. And this one here, Greg, is going to involve you and your eviction skills. But between Bruno and Cilna, please, guys, all of you jump in on this as well. So the question is, I bought a unit in a block of flats, and I discovered that there were illegal occupants in this particular unit. And now I'm trying to conduct an eviction. And I don't actually know, there could have been illegal occupants in the other units as well in this block of flats. And while I'm trying to conduct the eviction, the court's saying I need a municipal report. Now, what on earth does the municipality have to do with my unit, apart from collecting the water that I use, or the electricity, or whatever it is, or my rates? I don't see why I need to, what's a municipal report here? So the second part of the question, that was the first part. The second part is they're saying that the municipality needs to provide alternate accommodation. Why? this is my unit. Like, I just want to go in and live there. So, Greg, I think I'm going to throw this one to you quickly, and then we'll open the floor up for the question.
Sure. You know, the evolution of PI, we were all familiar with from, I think it was what, 1998 onwards. There was a lot of stuff in PI that wasn't really seen for quite a long time. Then, from about 2005, 2006 onwards, the anti-eviction NGO guys started focusing on what PI really said, and involving the city council in issues of eviction. And you'll all be familiar with the Constitutional Court case in Blue Moonlight, which basically said that if anyone faces homelessness, there is an obligation on the local authority to provide temporary emergency accommodation, not housing, temporary emergency accommodation. This was then compounded in the Constitutional Court case of De Wet NO, where basically the court said if there's a situation where there was a danger of homelessness, the court couldn't operate without a report from the city council. So we changed all of our practices. I'm sure that Cilna and Bruno did the same. We started routinely joining the city. Obviously, there are matters where there is no danger of homelessness, where it's pretty clear. Many respondents will allege that danger. I've literally evicted people from Sandhurst where they've claimed a danger of homelessness. Clearly nonsense, but everyone will ask it. It's much harder in the courts to justify a danger of homelessness than just for the asking. So it's not that simple. But I know a lot of courts, a lot of judges, if they fear, and in fact it's the law, if they fear that someone is going to be homeless upon eviction, especially if you're evicting from a shack or maybe a converted warehouse or something like that, they will want a report from the municipality. Now, for many years, the municipality filed a kind of rote report that said, we got nothing, but that's not good enough. So if there's a situation in this building, for example, where the court has clearly come to the conclusion, especially over COVID times, that there's that the people in the unit or in the block might be homeless but for this accommodation, they will call for a report from the city. Now, the city are quite good at assessing and reporting, and they certainly aren't going to find a danger of homelessness where there isn't such a danger. Getting the city to file the report is slightly more tricky. Sometimes the court will order them to do so. Sometimes they will do so mere motu, but generally you're going to have to squeeze them a bit to get that report. And as I said earlier, the real danger of homelessness is quite unusual, and the ability of a tenant, ex-tenant, to justify a danger of homelessness, the burden is a lot higher than it would seem. So overwhelmingly, what we've found when the city reports, the city finds there isn't a danger of homelessness in most cases, and the court accepts that. The city is a neutral third party with a constitutional obligation, and if the city says there's no danger, then the courts will generally accept that. If the city says there is a danger, it has the obligation to provide. Now, that's where things get tricky, because the city doesn't have a lot of accommodation. And if there's any kind of scale, if one's talking about a building, an entire building, for example, you potentially are going to wait for quite a long time before the city can provide that accommodation. Now, there are some signs that the sort of log jam that's existed for probably 12 or 13 years is easing, but it is still there. We've got a number of matters, probably 20, where we are waiting for that log jam to ease. The first of those, a building called Kiribati, which was the subject of that De Wet NO matter that I was telling you about, literally relocated 2 weeks ago after 6 years. Admittedly, the first 4 of those years were while litigation was happening. The city were obviously trying to resist their obligation to provide alternative accommodation routinely, and also had a view of how that accommodation should look, which is different from the view that the NGO sector had. So my own estimation of this is that the logjam is easing. It's going to be a while before it goes away. But in general terms, if the court has raised the fear of homelessness, there will need to be a report done. The court will need that report. And based on that, will order either an eviction if there's no danger of homelessness, or the city must provide in time X, which is awkward. That spun off into a whole different fight. We're all familiar with the Modderklip case, the constitutional damages case, where if you're obliged to fulfill the state's housing obligations, as you have been, it would appear, surely you have an obligation to be compensated. We've got two matters racing for court on this very subject, where we're hoping to get a constitutional damages type ruling in these circumstances. And I think when those orders start happening, the city might suddenly find its alternatives a little more vigorously. Joburg is better than Ekurhuleni. Ekurhuleni is better than Tshwane. Tshwane is better than Mogale, which is useless. So there's kind of a cascade. Depends where you're evicting. But Cilna, I think you've got a fight in Mogale too, so you'll endorse my theory.
That's why I'm having such a laugh at your candid scales of municipality support.
Oh, no. Joburg's pretty good, as I say. Ekurhuleni,
yes.
You know the cascade. But yeah, it's been quite a fight to get the NGO sector targeted Joburg to have their fights because Joburg's the richest municipality. There's the best prospect of getting a decent order against Joburg than against some small under-resourced municipality in the countryside, So we've had the fights, and Joburg as a result is quite a bit better than most. But as I say, some of them are just plain, well, no, it's not our obligation. Yes, it is. No, it's not. Look at the law. Don't see what the Constitutional Court said. So I'm afraid we're in that phase. And the problem is with Mogale, because they have no plan, because they have no program, they will fight every corner, because if it emerges that they have no plan, they're going to be embarrassed. And it's an election year. So that.
Sure.
So what's actually quite interesting is some of these reports. I don't know if you noticed this, Greg, and especially when dealing with like suburban areas, because I don't know what sort of attention they give to each individual area, but we actually found that certain sections of the report contradicted other sections. So I don't know if you ever experienced that, yeah. But I think that's changed now, like since I think this was about a year and a half ago.
Yeah.
But on the one hand, they were saying that the occupiers weren't entitled to T, so temporary emergency accommodation. They weren't entitled. But then at the back of the report, they said, well, we don't have enough information to make a call. So we asked the courts to postpone this for a year and
Forever.
it was like a year, and we'll come back to court next year with an assessment. But I think I haven't seen that recently, but it is exactly the story that you're portraying. Is there's a lot of testing. So when I started out in practice, we never cited the municipality.
No,
I think we served the section 4.2 and was like, there you go, it's done, we finished.
I just want to find out something, right? So I understand now you're talking about, the risk of homelessness, and the municipality needs to take that into account. But what about me? What about me as the property owner? Can I go to the municipality and tell them, hey, listen, I'm also going to be homeless. So these people are homeless. I'm going to be homeless. You guys put me up. I found a nice hotel for myself. Please, sorry, my lights just failed. Please, can you guys put me up?
Yeah.
Is that possible? Can I
Chris,
do that?
you've hit the nail on the head. And I mean, Bruno and Cilna and I have had this discussion time and time again, year after year. There seems to be a structural assumption that the property owner is fine and therefore they must look after themselves, which is obviously not always the case. Even the wealthiest property owners need and are entitled to that rental. So it is a problem, and it is interpreted very much in favor of the person facing eviction. That's why I'm really looking forward to these cases coming to fruition. The first one will be heard, I think it's the 9th of May, because I think when that little trigger is pulled, it's going to cause some anxiety on the part of the state in its various forms, because now suddenly Chris, who needs his own property, is going to be able to say, well, okay, you've made me house the homeless or the potentially homeless for a while, right? You owe me something, and this is what it is. So I think it's going to be quite a big fight, but I think it's one we're going to win.
And I must say, if I can weigh in on that, Greg, I just want to explain exactly what you're saying for the benefit of our viewers. So the constitutional damages claim that Greg is talking about is the obligation of the city to provide this accommodation, and they're dragging the feet. The damages claim that, Greg, correct me if I'm wrong, but I think I'm understanding you correctly here, lies with the municipality, because they have a constitutional obligation, which was confirmed in multiple constitutional court cases. Now what they're doing is, by delaying the reporting, by delaying providing the accommodation, they are effectively causing the damage to the property owner, to your question, Chris. So why this is exciting for, again, benefit of the viewers here, the moment you have a case law, the moment you have a successful case in court, it forms part of a precedent system, and other courts will have to follow this. So Greg has always been one of my ultimate heroes because of the initial case we talked about, Blue Moonlight Properties. When I came straight into evictions, and I think I was about 25 when I started doing evictions, and I read these cases, and I still remember the first day I met you in person, Greg. I was so starstruck. I was like, this is the attorney of record on Blue Moonlight Properties. And when you then say you're busy with stuff like creating case law for us, on constitutional damages, I'm rooting for you. If there's one person that can do this, it's definitely you, Greg. So now it's out in the open. I'm always a little starstruck when it comes to Greg. He is my absolute eviction hero.
Kind words. I'm now embarrassed and right back at you. But yeah, it's you've explained it exactly spot on. If you, Chris, are forced to fulfill the role of the state in providing temporary emergency accommodation, sorry, it's not that easy. Somebody must pay for that. And it's not conventional damages, constitutional damages, because these guys are forcing you to fulfill their constitutional obligations.
Greg, out of interest though, because this is often a debate, and I mean, obviously we'll see, sometimes we manage to beat the state in damages and sometimes not. But I mean, it's that old adage or principle of, if the state, for instance, doesn't enforce certain laws with respect to criminals and something happens, you could potentially sue the state for some sort of damage. So here we're looking at the provision of accommodation and saying, well, it's your obligation. So we all agree it's their obligation, but the possibility of them actually doing it is very different from the fact that they've got the obligation to do it. And that's always something in South Africa that's kind of come to the fore in these arguments is, but you cannot expect us to have the capacity to do these things, so we're not at fault. So delictually speaking, delictually speaking, how would you say that they're at fault for the sake of claiming the damage?
It's not a delict claim. It's an out-and-out constitutional damages claim, and the advantage we have is an order directing them to provide temporary emergency accommodation by date X. So in the one case, they were ordered, Ekurhuleni were ordered back in 2015 to provide within 6 months and didn't, and are now on record and saying it'll take them 7 more years. Joburg were ordered to provide in the De Wet NO matter by end of June 2019 and did the move 2 weeks ago. So the advantage we have, the unusual advantage we have in, to your question, is we have court orders. In certainly the one instance taken by agreement. So that, in our thinking, triggers that constitutional obligation much harder than if it was simply the fallback, there's a general obligation to provide. So having been ordered to do so, and having then failed within the time ordered, that's at least that date is the date by when constitutional damages are triggered.
100%. I agree. I agree with that, and I must say that would be handy, because way back when I was very new to evictions, it must have been about 2009, 2010 actually. I remember I was pregnant, 2010, and I did my first big farm eviction, and it was Municipal City, and they started installing services on the vacant piece of land. Well, then no longer vacant, but for the squatters. Municipal City provided utilities and stuff, which obviously created the perception that they were entitled to be there. And weirdly enough, way back when, I was successful with a cost order against Municipal City. And obviously for a big eviction like that, you tax out a good 120 odd thousand rand. And again, didn't pay until the sheriff started removing filing cabinets and paid the legal costs. And then there was a bit of, for about a year or two, they were definitely a bit better. But the problem is, we don't want to get cost orders against municipalities. We don't want, as ratepayers, to have the municipalities pay for evictions, pay damages, because we just need them to do what they're supposed to do, because effectively, otherwise, as the ratepayers are paying for the damages. But we cannot do it in any other way. If the cities doesn't feel it, if the municipalities doesn't feel their failure to support and failure to provide what they have to for their ratepayers, unfortunately, we're going to have to then start touching the pockets. Can't you do like a bonus proprio sort of order against the mayor? Come on, do that too, Greg, so the ratepayers don't have to. If Greg can do it, no one can. I know you can. Yeah, please, let's do that against the mayor. Sorry, Mr. Mayor, but we need that.
No, agreed. Look, I mean, we have to hit the municipal manager nowadays. I think the case will puts the poor municipal manager as the fella, but so be it.
Sorry.
Thank you so much, guys. Thank you, Greg. Thank you for that, Greg, for that wealth of information. Cilna, Bruno, and to our viewers for joining us today. We've come to the end of this episode. It's always a pleasure to have you all with us. And please join us for next week's episode, Wednesday, 6 o'clock. Hopefully we have a full house again, and we'll see you then. Thank you so much, everyone. Bye, Bruno. Bye, Cilna. Bye, Greg.
Thank you.
Thanks, guys.
Bye.
Thanks, Chris.
Bye.
Cheers, everyone.